All right. Good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of inherited property, clearing title, deferred property taxes, and other probate concerns. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the a month of service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Rachel Gutierrez. Also, our presenting partner with the Texas Legal Services Center, we have Ms. Lisa Nelson. Also joining us and presenting for today, we have the Harris County Tax Assessor Collector's Office, Ms. Jamie Duong, as well as the Harris Central Appraisal District, we have Ms. Mabel Menifee, who will all be presenting the information for you today. Also included in the partnership, though, we also have Lone Star Legal Aid, the Houston Bar Association, Houston Volunteer Lawyers, and the Earl Carl Institute. And together we make up a month of service. And month of service is the collaboration of all nine of our organizations. We've come together each month and offer a variety of workshops, resources, information to the community relative to asset protection, asset building, the maintaining of generational wealth, and community empowerment. And one of those sessions in this series is the Clearing Title workshop. This is actually kind of like the part two of last Thursday's presentation, which was the wills and estate planning and why do you need it. So we had a lot of questions afterwards following that one up. So we decided to add the clearing title workshop. So for people that have heirship issues or not sure what to do or how to go about the process of transferring ownership for property that has been in their family for years, where you've got multiple heirs, and then where people have potentially have had deferred property taxes. They don't know what to do after someone actually passes away. So, which is why we included the Harris County's Tax Assessor Collector's Office and the Appraisal District to tell you about what that process is like when you've got deferred property taxes and what your payment options are, as well as the heirship exemptions that people can now become eligible for when they inherit property and there are multiple heirs. So we're here today to specifically talk about that information. Yesterday's presentation we had in regards to property taxes and property tax protests. So we will be sending out a copy of the link of that presentation from yesterday. So if you are here about property tax and protest, we're going to kind of get into a little bit of information, but the majority of the details that we're going to be going over today is about inherited property and clearing taxes and other probate concerns. So we want to thank you guys for joining us today. Again, for a month of service, we know that there are a lot of underserved communities that are out there, people that don't know where to go for particular information, for resources, and what's available for them that they can take advantage of for free. There's a lot of misinformation that kind of gets thrown out there, especially as it relates to heirship property and what the process is. So we hopefully put a lot of those misnomers to rest for you for today. There's going to be a lot of information covered here. So we do invite you to come back and hear a live presentation every single month. We are here the second Thursday of each month with this presentation. So in case there's a question that you may have later on, you have the opportunity to come back and ask the questions directly for your answers. We do encourage you to be as interactive as you'd like to possibly be. Feel free to type whatever questions that you have into the chat. We are also recording and broadcasting live on our social media platform on Facebook. So we do want to try to protect your privacy as much as you can. So in asking your questions, we try to ask you to be as general as you possibly can so that your personal detail information is not getting out there for everybody to have access to. And again, we are recording this session. So a link of the recording will be sent out to everyone after this session is over with so that you can go back and hopefully share the information with other family members or whomever that may also find this information to be beneficial. So again, there's a lot that we got to cover here today. And we want to thank you guys for continuing to join. If you're here for the first time, thank you for attending this month of service presentation. When we do, again, hope you enjoy it and get the information that you need. So without further ado, we're going to move right on. Oh, give the disclaimer out. I'm sorry. Information that we do present here, as well as all of our other workshops, is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to our legal service partners if you find yourselves in need of any civil legal assistance. And Rachel's later on is going to give you information about the pre-assessment and referral process through the City of Houston's Department of Neighborhoods. So stay tuned for more information about that. So without further ado, we're going to get into our introductions and right on into your presentation. So Ms. Jamie.
Good afternoon, everyone. Thank you so much for making the time to join us today. My name is Jamie Duong. On behalf of your Harris County Tax Assessor Collector, Ms. Ann Harris-Bennett, we want to welcome you to our session here. Our goal here is to provide information for you and to provide a resource for you to reach out. And, today's presentation will covers, what to do with taxes, what to do when you inherit your property, and check to see if there are any deferrals that may have outstanding taxes out there, and what happens when you receive that tax bill. We'll provide that information. And again, if you have questions beyond that, please feel free to reach out to our partners and we'll be happy to assist you. Thank you.
Okay, Ms. Mabel.
All right. Okay.
Your camera's off.
All right.
Okay.
Well, good afternoon, everyone. This is Mabel Menifee with Harris Central Appraisal District. And it's a pleasure to be here with you this afternoon. I'm going to be providing you with some information, and hopefully it answers to any questions that you might have that may be generated by Lisa's presentation on clearing title on inherited property. Primarily, we're going to talk about exemptions and some things that you need to know about how those can affect your ownership rights, as well as any information in terms of clearing up property taxes. So I'm looking forward to talking with you, and providing you with that information after Lisa's presentation.
Okay, Ms. Rachel.
Thank you, Nia. Good afternoon, everyone. My name is Rachel Gutierrez. I am the Community Outreach Coordinator for the Department of Neighborhoods, Office of Neighborhood Engagement. On behalf of the Mayor Whitmire, and our Director Sims, we welcome you to the Month of Service program. Thank you so much to our partners to be able to take out their time to provide this vital information to you all, so that you all can take advantage and take advantage, but also educate yourselves and those around you about the importance of not just your inherited property, your estate planning. There's other legal advice that we give that you can take advantage of that may affect a portion of your life or somebody that you know. So we encourage you to continue to engage with us, to take advantages of the services, because you never know when you're going to need it. You may not need it now, but something may happen in the future. And with you gaining the knowledge that you learned from here today, you can either prevent or have a plan of action to how to address that issue. So spread the word. Knowledge is power. As we have a quote here, the street attorneys or the street lawyers or the street, they're not, they may mean well, but the actual factual information is brought to you by us, and we surely encourage you to take advantage again, and to invite others, those in your community, those in your the grocery store, those at church. It's virtual, so they have a way to be wherever they are to take advantage of this. And so again, we appreciate every one of you, and thank you again, and enjoy the presentation for today.
All right, Miss Lisa.
Thank you, everybody, for joining us this afternoon. We're happy that you decided to spend some time with us. My name is Lisa Nelson, and I'm a staff attorney at Texas Legal Service Center. I work on the Texas Law Help website. And I'm going to talk today about probate and clearing title. So let's get started.
Okay.
Okay.
That's good.
Okay, do I have them on the right screens?
Yep, you're good.
Great, thank you. Okay. This comes about because there's a lot of people. I used to work at the Earl Carl Institute and property preservation. There's a lot of people who don't realize that they don't have clear title to their property. And one of the many problems with not having clear title is you don't get your property tax exemptions, which is why I asked Mabel and Jamie to join with this presentation. So I'm going to give you an overview kind of as a follow-up part 2 of last Thursday's class. Then we're going to cover how you clear title to your family property and how you can make sure that your property stays in the family and continues getting handed down through the generations. I'll hand it over to Mabel and Jamie to talk about property taxes. And then at the end, we have plenty of time for questions. TLSC was founded in 1981. We've got more than a dozen practice areas. We have a lot of departments to help with parenting issues, child support, child custody. We have Texas Law Hotline, which is a legal hotline for people over the age of 60. And we also look at impact litigation to change to work for civil justice in the state of Texas. And our basic mission is just to help those who are vulnerable and do not have access to attorneys by educating them and empowering them. I keep these vocabulary words up there because attorneys tend to have a bad habit of throwing all these words around, and a lot of people don't know what they say. And I have it as a slide so that when you get the recording in a few days, you will be able to refer to it to educate yourself. So decedent is anybody who's passed away. Testate is someone who passed away with a will. And a testator is the name we use for the person who is signing the will, the person who has a will in place. Someone who is intestate died without a will. And a will is a legal document which states how the testator's property is to be distributed at death. Estate is just a fancy word for your stuff. It's the property that you own, both real estate and personal property that is owned by the decedent at the time of death. Probate is the court process for winding up a person's affair. It is called administration when someone passes without a will. And then the person in charge of wrapping up your affairs is called the executor, administrator, or personal representative. Personal representative is the generic term for anyone in charge of a state, whatever type of estate it is. If they passed away with a will, the person in charge is called an executor, and they're called an administrator for people responsible of estates that were intestate. And an heir or beneficiary is the person who inherits either through a will or by the law. A lot of people think they've handled all their affairs when they have powers of attorney. Powers of attorney are only valid while a person is living. Once that person is passed, those powers of attorney are no longer valid. Spouses need to have separate wills. I don't run into this as often as I used to, but it used to be that people would write everything out on one page, both spouses would sign it and think they were good to go. That might work, but it's much better, and it's legally required to have separate wills. A lot of people think I'm married and Texas has community property, so I'm not worried about having a will. That's not true. A spouse, if someone passes without a will and they have children from another relationship, those children are entitled to half their estate. So this runs into tricky situations. For example, if you're married to someone who owned a house before you got married, that's their separate property. The surviving spouse has a right to stay in that house if it's separate property for their lifetime. They can't sell the house, but they can remain in it to the rest of their life. They are responsible to pay property taxes and to maintain the property. And an executor has to be over the age of 18. They cannot, it used to be that they could not have a felony conviction. There's some exceptions. The law's changed a little. And it's also best if they live in the state of Texas. Rachel is going to talk later this afternoon about a great citywide program for getting a valid will. You can do your own will in Texas, but I highly recommend having an attorney at least review your will. And there's so many great opportunities for will clinics where you can get your wills prepared for free. I don't recommend using websites like LegalZoom. People think it's great because you can get a will for $100. that ends up being very expensive because those wills may not be valid in the state. The one place where you can get will forms that are approved by the Texas Supreme Court is texaslawhelp.org, the website I work on. We do have will forms that have been approved by the Texas Supreme Court and that you can fill out yourself. I already said spouses must have separate wills. Texas law also allows you to handwrite your wills. It's known as a holographic will. This was great when we were in lockdown for COVID because I gave people instructions on how to write out a will in their own handwriting, and they didn't have to worry when all of our offices were closed and we were staying home to be safe. My website has instructions on that. So if you want information about a holographic will, go to texaslawhelp.org. And be sure to keep your will in a safe place and let at least the person who you've appointed to be your executor where the will is. If your executor cannot find your original will, Texas law presumes that the will has been revoked. And you can probate a copy of a will, but there's a lot of hoops to jump through. And this is really important. If you die without a legally valid will, the law determines who will inherit your property. That might not be what your wishes are. You may not have children, but you want your property to go to your godchild, to your nieces and nephews. If you pass away without a will, the law determines who gets your property, and it would not be the ones that you wanted to have your property. One of the things that it can be frustrating to people in Texas is you do need an attorney to probate a will. And there's a really good reason for it. It's not just so that attorneys can make a lot of money. The probate is a little more complicated, and attorneys know the best way to proceed, especially if you can't find a will. So if your loved one dies without a will, you can file an application for administration. Depending on circumstances, you either have an independent or dependent administration. Independent has very limited court involvement. It's very close to probating a will, but there's a lot of strict circumstances that allow it to be independent. If your heirs do not agree, the court will order a dependent administration. If you pass away with a minor child, the court will require dependent administration. This is because the court wants to make sure that the administrator is doing their job, that they're providing for all the heirs properly, that they're managing the estate properly and wrapping up those affairs. But that is very expensive. If you have a dependent administration, you have to get court approval for every action. I had a dependent administration once that I represented, and we had to get permission to pay the light bill every month. We had to get court permission to have the yard mowed. I mean, it was incredibly expensive for our clients, because they have to pay those attorney's fees plus the filing fees. And in extremely limited circumstances, you can file a small estate affidavit. Probate assets are the property that passes under a will. That can be your house. It's your personal property. So household items, your cars, your clothes, any of your property. Texas also has what's called non-probate assets, and it's a good law because there's things that won't pass under a will or in accordance with the probate court. Those assets pass in accordance with the terms of a contract. So examples would be any insurance policies you have, retirement plans, and payable on death accounts. If you have payable on death beneficiaries on all your financial accounts and a transfer on death deed for your house, your family may not need to probate your will, which will save your family quite a lot of money. So a very important tip to learn from today is check your bank accounts, check any other retirement accounts, all of those things, and make sure they have proper payable on death beneficiaries. In those situations, the people that inherit, say, your bank account through a payable on death beneficiary, they can have access to those funds right away. They don't have to wait the several months or years it can take to probate a will. Small estate affidavits are only appropriate in extremely limited circumstances. And you cannot use it unless You cannot use a small estate affidavit to transfer real property unless there is a surviving spouse or a child under the age of 18. You cannot use it if it's just surviving children. Even if it's an adult child who lived in someone's home, took care of their parent, they cannot use a small estate affidavit to transfer property. The small estate affidavit is a form that the court puts out, and you have to use the court's form. And all the heirs have to sign off, agreeing with everything stated in the small estate affidavit. You cannot use this process if the deceased person did not have, you cannot use the process if the deceased person had a will. And the value of the assets has to be greater than the debts of the estate. So for example, say you have an estate that's worth $10,000, but you've got $30,000 in debt and credit cards and student loan, you would not be able to use a small estate affidavit. Now, the homestead is not included in the estate. The homestead is exempt property, and the estate has to be less than $75,000. Whether you have a will or not, there's a pretty similar process for going through the court procedures. The attorney files an application to probate along with the original will, or else files an application for administration. It has to be posted for 10 days. That's on the bulletin board downtown at the courthouse. After 10 days, the attorney can schedule the hearing. That does not mean that you will be able to go to court that quickly. In Harris County, it often runs 6 months or more before you can get a court date because the courts are just that busy. You go in front of a judge. It's a pretty simple procedure. It tends to be intimidating to feel like you're in court and you're in a judge and people are worried that the judge is going to try to trip you up. This is a very friendly procedure. You just go through a small statement with your attorney explaining, the situation of your loved one. The judge will either approve the will, admit the will to probate, or granted administration. At that point, the personal rep would receive either letters testamentary or administration, which is their official proof that they are in charge of that estate. The personal representative would then gather all the estate assets and open a bank account for the estate that does require a tax ID number. The estate is a legal entity, so it has to have a tax ID. The attorney notifies creditors. It is important to know, that the personal representative absolutely is not responsible for any of the estate's debts. The estate's debts are paid by the estate's assets. Creditors have to go through a very specific legal process to get paid. So please don't start paying bills the minute they come in. Make them go through the court, make those creditors go through the court process. And the attorney and the personal representative prepare an inventory, which is a list of property as of the date of death. Once that inventory is approved, if it's a probate of a will or an independent administration, the estate normally is closed shortly after that. If it's dependent administration, it takes a lot longer to wrap up the affairs. A lot of people live in a family home, and because it's been in their family for multiple generations, they think that everything is fine. It's my family home. Of course I own it. And then we get a hurricane or a winter storm, and they apply for assistance. If you don't have clear title, you will not qualify for any of that assistance. So they end up in a mad rush to get title clear while there's still an open period for applications. Additionally, if you don't have clear title, you're not eligible for property tax exemptions or deferrals. So you're going to be spending a lot more money on taxes than you should be. Another thing with probate, and this is a very common misperception, people think that a will is it. If somebody has a will, they're good to go, everything's fine, we can just move on. You absolutely have to probate an estate in order to have clear title to the property and to be able to access financial accounts if there were not payable on death beneficiaries. There's a few options for using a court procedure to clear title. The general rule of thumb is that you need to probate a will or file an application for administration within 4 years of the date of death. 4 years means you can take time to grieve. You can take time to take care of yourself and be with your loved ones. You don't have to rush to the courthouse after someone passes. However, if it's been more than 4 years, there are a few exceptions. One of the things that I used to do a lot at Earl Carl was an application to probate as muniment of title. And you can do that if there is a will and it's been more than 4 years. And the final way that you can clear title is a petition for adverse possession. So traditional probate is, it's been less than 4 years since your loved one passed away. And you get an attorney and the attorney files the application and you go in front of the judge. To probate a will, the judge determines whether the decedent left a will compliant with Texas law. This is where I've had clients run into a lot of problems because they didn't want to spend the money. So they just, found something online and downloaded it. And those are written for the most general purposes and are not going to be compliant with the laws of every state. And as I've said, if they did not leave a will, you can file an application for administration. If it's been more than 4 years, you can file an application for probate as muniment of title. There must be a legally valid will in order to do that. And what that application states is that the only thing we need to do in this estate is clear title to a house. We don't need to do any other kind of administration. If it's been more than 4 years, everybody has to agree to probate the will. Anybody who is legally entitled to property, even if they weren't named in the will, has to agree. And once the judge signs the will to probate, filing certified copies of the signed order and the will, transfer the property to whoever is named in the will to inherit the house. So it's a pretty simple process. But if it's been 4 years, you have to have a good reason for why you didn't probate it. The best example I've ever seen is a woman who didn't know her husband had a will. And, so she went about with her business. And when they got ready to sell the house, they were clearing out the garage and she found a safe in the garage that she didn't even know her husband had. And that safe was his will. And I think it had been 20 years since her husband had passed. So she explained to the judge, I didn't know, I just found this. And the judge did accept that as a reason. Adverse possession is a legal principle that most people have heard of. It allows you to obtain legal ownership of a property based on your continuous occupation without permission from the legal owner for a specific time. Texas has several different statutes. There's a 10-year, a 15, and a 20. And there are certain things that you have to have fulfilled within those years. One thing that is a problem is you cannot use this procedure if you have permission to reside on the property. I ran into a case where someone was living in the family home and all the other relatives refused to sign title over to her. They said, you can live there, but we're not going to give you our share of the house. She could not use adverse possession because her siblings gave her permission to live there. And usually the length of time varies, but it's usually at least 15 years continuous in the house where you live there. Everyone knows you live there. You have your address there, you receive mail there, you keep the property up, so there's numerous requirements to show that this is my property. Everybody knows I live here. There's also a non-judicial way to clear title, and that's the affidavit of heirship. And an affidavit of heirship is a legal document that you file in the county clerk's office to pass property down to the current generation. We use this if the homeowner did not have a will or the will wasn't probated within 4 years, and it's a written description of who the survivors are. It has to be signed and notarized by 2 witnesses. They have to be people who could not legally inherit from the decedent, but knew the decedent very well, knew who their children were, knew that they didn't have children, all of those details. And it's really important that you have the full legal description, which is found on the deed. The legal description is not the legal description on your property tax bill. That is a much more abbreviated term. And the affidavit of heirship must be filed in the county where the property is located. There's a filing fee that varies by county, and it's dependent on the page. In Harris County right now, it usually is between $30 and $50. And the other counties, I believe, are a little bit less expensive with their filing fees. Now, a lot of people get confused between small estate affidavit and affidavit of heirship. You can only use a small estate affidavit when there is a surviving spouse or surviving minor children. You cannot use it with siblings. It's a very sad situation that a lot of people will go to the county clerk's office and say, I need to clear up my loved one's estate. They didn't have a will, and I can't afford an attorney. And the clerk would say, well, if you don't have an attorney, you can file a small estate affidavit. That is rarely true. And the filing fees for a small estate affidavit are $360. So somebody thinks that they can pass a house to the surviving adult children through a small estate affidavit. They prepare the document, they file it, they pay their $360, and then the judge won't sign it because it's not appropriate if it's not a surviving spouse. So in that case, you need to use an affidavit of heirship. An affidavit of heirship is the best way to transfer a home to adult children or other transferees. Now, the other difference between the two affidavits, affidavit of heirship only passes real property. It does not transfer anything else. Small estate affidavit, if someone passed and they did not have a house, but say they had some bank accounts, check with your bank first, but a lot of banks will allow you to pass the property through a small estate affidavit. Whenever I go through the lengthy process of clearing title up for someone so that the family home is now their home, I tell them, let's please do the right thing so that your children don't go through this. One of the best things in Texas probate law is the transfer on death deed. It's a simple, inexpensive way for a homeowner to transfer a house or other real estate to someone upon their death. The transfer on death deed absolutely does not affect the owner's rights during their lifetime. So the owner can still sell the property, use it as collateral to borrow, to get a loan, get property tax exemptions, etc. And the beneficiary has no rights until the owner passes away. The owner can also revoke that transfer on death deed and give the house to somebody else. Children under the age of 18 can't inherit property. So I had a situation where a gentleman wanted to leave his house to his grandchildren. All of the grandchildren were young children. And so my suggestion was to leave the house to his daughter. She could then sell the house and divide the money up among all of the grandkids. And the deed must be filed before your death in the county where the property is located. If it's not filed, you go to an attorney. They prepare your powers of attorney. They prepare your will. They prepare your transfer on death deed. And you put all those nice papers in a safe place. The deed is no good until it's filed, and it needs to be filed before you pass away. Now, we have a transfer on death toolkit at texaslawhelp.org. It will take you through all the steps. It has really detailed instructions and the form that you need to file with the court. And you really need to get the full legal description from an existing deed. You cannot use the description from your property tax bill. That could cause the deed to be incomplete, and your transfer on death deed could even become null and void. To find the legal description, if you don't have a copy of the deed, you can go to your county clerk's office and have them pull the deed. I also found a website where there's some websites where you can search for a deed online. Another great thing about the transfer on death deed is that it protects your property from Medicaid estate recovery. If you use Medicaid, for example, most people use Medicaid to pay for nursing home. once you and your surviving spouse pass away, Medicaid can seek to recover what it expended on you. If you transfer your house through a transfer on death deed, you are not subject to the Medicaid estate recovery plan. They can only go after your assets if you probate a will or have an administration. I'll put these resources in the chat as well. Our website is a self-help website, texaslawhelp.org. We also have Monday through Thursday from 10 to 2. You can get free legal advice from attorneys if you meet the income qualifications. But don't worry about coming if you're not sure that you will meet the income qualifications, because we can give anybody legal information. Earl Carl Property Preservation is their mission is to maintain and protect family wealth, generational wealth. Lone Star Legal Aid, Houston Volunteer Lawyers provide legal assistance to people for just about any problem you might have, except for criminal defense. Legal Line is a great resource through the Houston Bar Association, where you can call a number and get a pretty much unlimited discussion with an attorney. They can't take your case, but they can give you advice. And the Houston Lawyer Referral Service is great for locating attorneys that practice in your area. One of the best secrets about the Houston Lawyer Referral Service is that you can get a 30-minute consult for $20. So if you're concerned about paying for attorneys, you can use that $20 to find out if you like the attorney, find out what they recommend. And sometimes they will have attorneys that will charge you a lower rate. Thank you very much, and I'll be available for questions after the other presentations.
Miss Lisa, really quick before we get into Miss Mabel,
Sure.
there's a question here. What can you define what constitutes clear title?
Clear title, I came across a great explanation the other day, and I need to add a slide for that. Clear title means that there's not any encumbrances on the title. So for instance, if you live in a house that you inherited from somebody else, but you didn't go through either a probate process or an affidavit of heirship, you do not have clear title. You're not the legal owner of the house. Also, if there are any liens against your property, either a tax lien, any type of a mechanic's lien, that you don't have clear title then. If there's a judgment against you, people can file that judgment in the property records, and you will not have clear title because they want to make sure if you sell that house, they get paid. And I will find that full definition and I can give it when we have our questions at the end.
Okay, all right, good deal. All right, so the resources that Miss Lisa had for the other legal service partners, I will be emailing out that information to all of you guys if you didn't see it on the slide, along with their links for their website and their contact information. So all that will be included when I email out the link of this recording. In addition to that, part one of the sessions, which was the wills and estate planning presentation from last week, will also be included so that you guys will have the templates and get all the information that you need as it relates to creating an estate plan and the documents that actually make up an estate plan and how they need to be executed. So I will be forwarding all of those to all of you all as well. So with that being said, we're going to move on into Ms. Mabel with the Harris Central Appraisal District. She's going to get into quite a bit of information for you guys about various exemptions, including that heirship exemption she mentioned earlier. But as Ms. Lisa stated, there's a lot of those things that you can't get access to or can't take advantage of those various exemptions if you don't actually have clear title or you don't have those affidavits completed. So Ms. Mabel, why don't you go right ahead into your session?
So thank you, Nia. I'm trying to make sure that you can actually see it because I had switched out. I actually had the wrong presentation up earlier. And
okay,
now I'm just trying to make sure you can see it.
Just make sure you hit the green button on the bottom and to do the share.
Yeah, I did that. I'm just trying to bring it up.
Okay. Well, while you're doing that, I have a
Yeah,
quick
go on.
question for Miss Lisa again.
Okay.
Miss Lisa.
Sure. I found that definition real quick, if you want me.
Okay, go right ahead.
So a clear title generally means that no one else has a financial interest in your property. It also means there is no question of ownership and that the ownership history of a property can be easily traced. So in the county property records, you can look through the records and see who had the house originally and how it was passed down through the years. And I'll pop a link to this in the chat. This is a really handy guide that our partner Lone Star Legal Aid prepared after Hurricane Harvey. So it's specifically geared for disaster recovery, but I think it's helpful for anybody who has questions about property and titles.
Okay, so when
Okay,
you
so-
include that, then I'll click it and then make sure that it's included in our in the link as
Great.
is included as well. Miss
So
Mabel,
Lee-
would you?
I'm sorry. Are you seeing it now?
No, ma'am.
I
Take
apologize.
your time. But my question that I was having for you, Miss Lisa, is when someone passes away with or without a will, what, and I know you kind of briefly touched on it, what exactly are the steps? What's the process? What should somebody expect? Okay, my loved one passed away last week. Now I need to do what exactly?
You need to talk to an attorney, and this you have 4 years to do. Excuse me, 4 years to do this, and the attorney will determine what the best process is. Now, if it is a very small estate and there's a surviving spouse, you can absolutely do a small estate affidavit, which is just filed with the court and the judge signs off on it, and then the surviving spouse now owns the house. They can take the affidavit to the bank to get access to bank accounts. That only works with a surviving spouse. Otherwise, what you need to do is you need to do an application. The attorney will prepare either an application to probate or application for administration. That's filed with the court. It has to be on file for 10 days before the court can set a hearing. And in Harris County, it's not going to happen in 10 days. We're looking 6 months or more because the courts are so booked.
Okay. We see your screen, Miss Mabel. I see the email page.
I know. Hold on.
So, oh, you stopped it.
I did it because I'm trying to bring up the PowerPoint. That's my problem. I apologize. It will. Here we go. Hopefully.
And
Now,
Miss Lisa, why does someone need to use an attorney to file application for probate?
Because it's the short answer is it's required by law. The long answer is it's more complicated than it seems. I mean, I can explain it to you so that you understand it and you think you can go about it, but you are allowed by law to represent yourself in most legal cases. But in the case of probate, where it's an estate, you're not just representing yourself, you're also representing the estate. The estate is considered a separate legal entity. And you cannot, if you needed to go to court, say Rachel needs to go to court and she says, yeah, I've seen you at all those Amos presentations. I bet you could help me probate this will. You couldn't do that because you can't be responsible. You can't file any kind of lawsuit representing somebody else if you're not an attorney. And the law wants to make sure, and it's also to protect both the executor and the estate, so that you know, the executor can say, I did everything according to law. This is what the will told me to do. You know, I'm signing an affidavit that I fulfilled all the terms of the will. And the probate, the judge and the attorney are there to protect that executor from any legal actions.
Yeah, I say this just about every single month. People don't realize that there's a lot of work involved in being an executor or an administrator of somebody's estate. It's a lot of responsibility. So don't be in a rush to be in charge of taking care of whatever needs to be taken care of, because it's a lot of work from talking to the attorney to filing the application for probate, for going to actual court, talking to the banks, getting those letters of testamentary, having to file a tax ID number for the estate, opening up new bank accounts for the estate, documenting, sending reports, completing inventory. It's a lot of work.
I love that you bring this
It-
up every time. I've got my own funny personal experience. I've been doing probate law for quite a few years. A few years ago, my aunt passed away and I was her executor. I had never been an executor before and I was honored. I thought, she really trusts me. It was so much work. You know, it was really interesting to see the process from the view of the executor as opposed to the attorney, because it is. You've got to file that inventory. You've got to open a bank account. You've got to prepare their taxes for their last year. You've got to, you know, sign off and make sure everything's taken care of. It is a full-time job.
It is. It is. It is. So what one bit of advice I would give to anybody else that's watching, or if you know of anybody, take a moment to grieve, go through that process before you, if you can help it, because like Miss Lisa said, the probate process, you know, is going to go on for years. I mean, it's not going to be an overnight kind of thing. It'll take you months before you can actually get a court date to even to be seen by a judge, to get letters, testamentary, or what have you. And then you know, it could be up to 4 years. So in that time, or prior to starting that time, because like I said, it does become a lot of work, take the time to grieve and get yourself mentally prepared for the work that's about to happen, because there's nothing more frustrating than trying to, and I know in a lot of cases, and what we're trying to prevent here today is for people to make sure that they actually have access to people's bank accounts, to make sure that things get taken care of, that funeral arrangements are done and things of that nature. So that way that you're not stressed out about, how am I going to pay the mortgage? I was relying on this person's salary or access to the bank accounts to get a mortgage paid, or to pay taxes, or to pay insurance, and so on and so forth. And you don't have access to any of those funds. But you can't get access until you actually go through the probate process, which could take months, which will take months
Yes.
before you actually even do it. And then now you can't talk to the bank to actually make arrangements or payment arrangements, because you're not considered the executor of the estate yet. It's a lot of work. So make sure that things are kind of in place prior to you passing, so that you don't run into a lot of these issues, by making sure you at least have a transfer on death deed or payable on death beneficiaries on your accounts, so that someone actually has access to it to take care of things. So, and a lot of people also, we were talking about last week, they assume that because you're someone's power of attorney, that the power of attorney gives them access to everything. So can you explain how the power of attorney works as it relates to when someone passes?
Absolutely. And I want to add another tip, because you reminded me of something else. If you are the named executor and you know that someone is ill, someone is going to pass away. With my aunt, she had cancer, so I knew she was going to pass. I withdrew, because I was also her power of attorney. I was able to withdraw money from her bank account and open up a separate account, because once a bank finds out that someone has passed, they close that account. And sometimes it's within 24 hours of the date of death. And you're going to need a lot of money up front. You're going to need money for the funeral. You're going to need money to, you know, pay bills, things like that. So you want to be able to have access before you open probate, because you don't want to have to wait 6 months to have a funeral, or 6 months to make payments on keeping the lights on in the house, or things like that. But the power of attorney is when someone stands in your shoes to take care of things when you're not able to care for them yourself. You know, a power of attorney can do, there's two. The medical power of attorney is you give the doctors permission to talk to this person when you are not able. Like if you're having surgery, you need to have a medical power of attorney in place so that the doctor can talk to that person if something comes up during the surgery. The financial power of attorney is also called the statutory durable power of attorney. And that person steps in your shoes to take care of all of your financial affairs. You can have it either effective immediately or effective when a doctor declares that you're disabled. My mother wanted it effective immediately because she wanted me to start taking care of her business. That person can control everything while you are living, but once you pass away, you do need to have the court appoint a representative to handle everything.
Okay. I am trying to get this presentation to share that I just got from Miss Mabel, since we were having some technical issues there. And now I can't get it to open. It was
Oh my
just
gosh.
You know,
Hold on, I,
somebody told me that it's nothing but the devil. Every time you try to get some information out to people that they know that they need, and we gotta provide them with this service, then it's always going to be some kind of obstacle to try to stop you. But we're gonna get this information
we're
out to
gonna
you
get
guys.
this.
So we're gonna get this
Hold on.
information out to y'all. So by any means, we're gonna
There we
get it.
go.
I've got it. All right.
Got it.
So
You have it now?
yes, ma'am.
All righty, and I actually have it too. Can you guys see me?
Yes, ma'am.
Oh, okay. I can't see me, but that's fine. I don't really care. Good afternoon, everyone. Sorry about that. I think there was something going on between one of my drives and then something called OneDrive. And anyway, uh, thank you. I'm gonna pick up on where Lisa left off in terms of especially with information, particularly with information about the exemptions process and property taxes and how that can all kind of work into making sure that how that sort of fits in with clearing your title on inherited property and things that heirs as well as other property owners need to know when it comes to exemptions. So hopefully that not only those of you who are looking for information on clearing title can find out some useful information, but we can also share other things about the property tax system as it relates to exemptions. So central, just kind of a little bit of background on HCAD. A lot of people don't know who we are, what we do, or just have a very narrow idea of some of the things that we do. But we are the central appraisal district for the county, for Harris County. There is one in each county in Texas established by the state legislature. And what our responsibilities are, appraising all county property, residential, commercial, agricultural, industrial property throughout the state. And another thing that we also do is to administer exemptions. The appraisal process takes place generally, the magic date is usually January the 1st of each year, and and keeping that date in mind, you may hear me say some other things about that date as we go into the presentation. But we're required to value property at 100% of market value as of January the 1st of each year. And that basically means the condition or characteristics of the property that were there on January the 1st of each year. We also administer the exemptions, and we record and administer the exemptions, and then those are provided to the taxing jurisdictions as well as the tax office, and they're used in calculating your tax bills. We'll talk about what exemptions are. And then we certify the appraisal rolls annually for all of the taxing jurisdictions. And when I speak of taxing jurisdictions, I'm talking about the city, the county, school districts, the entities that you pay taxes to. So basically, because Texas does not have a state income tax, property taxes tend to play an outsized role in the funding of local services like your school districts, your police, fire protection, hospitals, the roads that we travel on each day, and keeping in mind too that tax laws originate with the Texas state legislature, and they're generally interpreted statewide for all the central appraisal districts. One of the reasons we recently had a name change, a lot of people, we go from Harris County Appraisal District that we were a few years ago to we're now the Harris Central Appraisal District, which is a name that a lot of appraisal districts already have around the state, but we did so in order to try and help alleviate some of the confusion that often came with people thinking we were part of the county government as opposed to being a subunit of the state. So I mentioned to you that January the 1st, we talked about that a little bit. That's the date of appraisal on all property, and that means appraisal's condition of the property as well as ownership in most cases is based on that January the 1st date for certain things. May 15th is the protest deadline that comes each year. Once you receive, as a property owner, you receive that annual value notice from HCAD, and you can file a protest if you disagree with that, which must be done May 15th or 30 days from the date of the notice, whichever one comes later. And then, of course, I mentioned once we certify and the jurisdictions set their tax rates, the tax bills are then going to be mailed out usually in late October or early to mid-November. And then on January the 1st, all of those are due. Your taxes are due and become delinquent on February the 1st. Let's get into the concept of exemptions and what they are, how they can save money, and how you go about getting them. So keeping in mind that exemptions are something that the individual, the property owner qualifies for. They have nothing to do necessarily when we're talking about residential property. They don't have anything to do with the dwelling necessarily. Exemptions are generally provided based on the eligibility of the owner. So that's important to keep in mind because once ownership changes, then the new owner, whoever that may be, whether it's an heir or whether they're selling the property on the open market, does not necessarily qualify for those exemptions. So said they're administered, HCAT administers those, and basically what they are the ones that residential property exemptions exempt a portion of your property's value from taxation. And basically that means it's a discount on your property taxes, and it's for your primary residence only. It's the one that you occupy as your primary residence. These are used by the taxing authorities to calculate your property tax bills. As I said, that comes off, that's the discount that you're gonna get off the tax rate. The most common ones are gonna be the general resident homestead exemption. If you own and occupy a property, then you undoubtedly have this. If you don't, you certainly should. And then there's the over 65. Once you turn the over 65, that's on top of the general resident homestead. There is something called an over 55 surviving. There's a disability exemption, certain exemptions for disabled veterans, as well as other service-related exemptions that individuals who may be die in the line of duty, perhaps a fire, police officer, whatever, they also receive, their spouses are eligible for certain additional exemptions as well. The general resident homestead exemption is the primary and the most common one. We provide those. You can apply for those at HCAT. Basically, you have to own and occupy the home, as I mentioned before, and we do require documentation, and that is proof of ownership, as well as a state-issued Texas driver's license or state-issued ID that where the address on that matches that of the property. One of the important things to also consider when reasons that you're going to want that general resident homestead exemption on the property, that people get them, is because it also provides a 10% appraisal increase cap each year. And for a lot of homes where their values have been rapidly ascending in recent years, sometimes as much as 35% or more, that having that exemption and that appraisal cap that comes along with it protects you from those rapidly increasing property values and taxes by limiting any increase in 1 year to no more than 10%. That's called the cap, the appraisal cap. You also get, as part of your general resident homestead exemption, $100,000 of exemption from off your school taxes, and that's a state law. All school districts are required to provide that discount. And basically what that means, if your home is a $300,000 home, your school taxes are only going to be based on $200,000, and that might also for school taxes. There are other exemptions that certain jurisdictions might offer. The city of Houston offers one. I believe it's $200,000 for the general resident off your property value. I could be wrong. Jamie will correct me on that, but they do offer a discount, as well as the county and some other entities. Just kind of depends where you live in the county at that point, who offers what. The over 65, as I mentioned before, is on top, is something you qualify for the entire year that you turn 65. So if your birthday is December 30th of 2024, you will get that. Once you've applied for it in December, you will get that exemption for the entire year. That also is true of the disability exemption. Have those two grouped together here because they basically provide the same benefits. One is for the homeowner who turns over 65. The other, the disability exemption, is one for any homeowner who may be disabled. And disabled in this context means that you're unable to work. You qualify for that through the Social Security, Federal Old Age Survivors and Disability Insurance Act. And many homeowners are not on Social Security, so they can also qualify through a position statement. We actually have that position statement available on our website for you to take and have completed. The benefit for both of those exemptions, you do get when you turn 65 or disability or disabled, you get a school tax ceiling or freeze or limitation. You may hear all three words, ceiling, freeze, or limitation, but essentially it means that the year that you turn 65, whatever your school taxes were, you will not pay any more than that amount. It freezes at that amount. It could go up or down for certain reasons. Primarily, it could go down if your value falls. It could go up mainly because you added some substantial improvements to the property. And we're not talking about regular maintenance, but things like you add an extra room, so you've added square footage, or you put a swimming pool in the backyard. That can cause your value to have to reset before that freeze is put back in place because you've increased the value of the home. Of course, you get all the exemptions from the general resident homestead, and then you're eligible for something to call the tax deferral. And you can also pay your taxes in installments without penalties. Jamie's going to talk a little bit about that in a minute. Other exemptions can also be granted. Additional over 65 exemptions can be granted by, again, individual jurisdictions, depending on where you live. The over 55 surviving spouse is simply the exemption that allows the surviving spouse of someone who had turned, a couple, for instance, who one had turned 65 and he or she passes away, and the over 55 surviving spouse simply allows that the surviving spouse, as long as he or she is 55 years of age, to continue those exemptions. They don't have to reapply for them. They don't have to be reset. They do need to let us know in terms of, when I say reapply, it means it won't reset, but they do need to let us know that they are the surviving spouse in the home. You continue to receive all those over 65 benefits. And of course, you can also apply for a tax deferral, or you're eligible to pay those taxes in an installment program. So this is one that really want to talk about too, because it was something that was not necessarily available a few years back, or perhaps it was, but it was too complicated for most people to recognize. And so it's kind of been pulled out, and we want to make sure that everyone understands that this particular one, it is the heirship exemption. And that's part of the application on the general resident homestead exemption. If you get to section 3 and you answer the question, is the property for which this application is submitted an heir property? And you answer yes, and do other heirs occupy the property? There are some additional steps or questions that you need to answer. And once you have properly submitted the application based on the heirship explanation, you can actually receive that 100% of the exemption, even though you may not own the home at 100%. Say you have 3 other siblings, so your legal ownership to the home is only 25%. But because you live and occupy your home as your primary residence, you can receive all those exemptions in the amount of 100%, as opposed to just 25% of the exemption. So you want to pay close attention to that for people who are living in heir property. Basically, the information that's going to be needed is the affidavit establishing your ownership interest in the property. And we actually have those forms available. We're going to need the death certificate of the prior owner, as well as a copy of the property's most recent utility bill. And some people know, why do you need that? And that's something to that provides proof that the property is indeed being occupied. And then any citations of court records or proceedings that you can provide us to ascertain, to show your interest in the property, your ownership interest in the property is also helpful. I will say that anyone who has questions about this can please feel free to call our exemptions department and you'll get a hold of someone who will be more than happy to walk you through this. So another fairly new one, and this one's even newer, is called the immediate homestead exemption. And this is primarily for individuals who are moving into either a new home that has never been occupied before or a home that had previously been a rental. Neither one of them had any exemptions on the property, right? So you can qualify for this immediate homestead exemption upon moving into the home, and you get the exemption on a prorated basis. You don't get it for the full year, but you get it from the time that you moved in. Say you moved in in May, then you're gonna get it for 7 months of the year. And that is when there are certain conditions that, again, if that's why I say it's for mainly a new home, but if the previous owner did not have the exemptions, or again, the home was never occupied, the exemptions will be granted, like you get that first year proration. The second year, you get the full exemption, and that's the year that your 10% cap is going to be established. However, if the home was previously occupied and owned and was receiving exemptions by the previous owner, those exemptions are going to remain on the property for the rest of that tax year. So essentially, you'll still be benefiting from the exemptions that were already on the home for that year. So I added this slide because I know in a lot of cases, people often think that once they purchase a home or they make a change down at the county clerk's office, that HCAT's going to automatically get that information, automatically get it, and a couple of weeks later, you look out and say on our website and say, hey, that's wrong, the information's wrong. So I wanted to tell everyone that if you want to make that easy, because the systems operating between various government entities don't always click at the same time. And so if you want to make sure that we have that information so that there's no delay in getting any of the exemptions that you might be looking forward to getting, or anything else, you can simply go out on our website and fill out something called a request to correct a name change or address on a real property account. That is Form 25.25B, and you can find that on our website. I'll show under Forms. In order to change or correct ownership, we will need some evidence that you will need to send with it. That's a closing statement or other evidence of title that needs to be attached, or your warranty deed. And again, this form is available on our website at www.hcat.org, and simply go to forms for that. So how do you apply? I mentioned that, and applying for the exemptions. It's important to remember that they're not granted automatically. You have to apply for them. So we have those forms as well on our website at www.hcat.org under forms. You can print them out and mail the paper form. You can submit in most cases online, or we also have a mobile app that you can download from the Apple Store or Google, or you can actually copy it and paste it into an email and send to us. Depending on when it's submitted, processing time can take longer depending on what time of year it is. If you do submit everything at once, and we don't have to come back and say, hey, you forgot to submit driver's license, or, well, there are 2 people on the account, 2 owners, and you only sent the driver's license for one, please send the driver's license for both owners, when it's a couple. And if we don't have those kinds of delays, the process will typically take around 90 days. However, as long as you file it in that year, you will get the credit for it for that year. So again, it's important to submit everything at once to avoid a delay in processing. Want to remind you once again, we do need that driver. Please be sure to submit your driver's license or state issued ID, Texas ID with it for anyone who doesn't drive. And we also have for the exemptions form, if you're still a little bit nervous or unsure about trying to fill it out online, we do have a how-to video that's out there now that accompanies the application that will walk you step by step through the process as you fill out the form. Another thing that's important, and this is a good thing to know if you are taking care of an heir property. We send out each year, typically in December, the annual exemption confirmations card. Kind of looks like this on the front, and then on the back, it's going to tell you information about just what your exemptions are. And we do ask, and state law requires that you notify us in writing if your eligibility for any of those exemptions has ended. So that kind of serves as a reminder to someone who may be moving into an heir's property to double check the exemptions or whatever they had on their property, because if they're moving in, those exemptions are not theirs. They belong to the previous owner, and they need to apply for the ones that they are eligible for. And also, please note that this particular form, if that person has moved away, they're not forwarded by the post office. So if you get it, nothing's changed, fine, throw it in the drawer. If you get it and you know that you need to take a look at it, please do so. If you do not get it, then what happens is, so as I said, they aren't forwarded. They come back to HCAT. The exemptions department will launch an investigation, mainly trying to, make efforts to contact the homeowner. If they are unable to, for whatever reason, then those exemptions are going to roll off. So just so that you know, if you don't remember receiving this, you want to give HCAT a call. So this is something I'm going to put out there for folks, now that we've kind of talked about the residential property exemptions for those of you who are living in the home as your primary residence. I did want to mention this as part of something that passed in November 2023 when we all voted on the constitutional amendment that raised our exemption rate on school taxes to $100,000, another $100,000. Another part of that bill included something called what they call a circuit breaker. And it's just a 3-year pilot program that the legislature passed to sort of relieve some pressure off of rising rental rates. And so what that does is it applies to those non-homesteaded properties that are valued at or below $5 million. And that's usually going to be rental properties, or maybe it's a second home that you own somewhere else in the state or wherever in the state. And so what this circuit breaker does for those properties is that your appraised value for the current year can exceed 20% of the appraised value for the preceding year. And again, that does exclude homestead and agricultural properties, which already have their exemptions processes in place. You must have owned the property by on January the 1st of 2023 for it to apply. And again, it provides that 20% cap, kind of like the 10% appraisal cap, but in this case, it's for non-homesteaded properties. So just for those of you that might have additional properties, and this will be automatically applied. It's not something that you would apply for. This is a copy of our website. And I've mentioned before, as you can see up here on that second blue bar, if you want to go out under property searches, maybe you just want to do a quick search, you're waiting on your exemption to be applied. It's going to say out there when you go out and do a property search and pull up your account under the exemptions column, it's going to say, if you have a residential homestead, general residential homestead, it's going to say residential homestead under the exemptions column. If you have an over 65 or a disabled, because we don't put out personal information on the website to say, oh, this person's an older citizen or they're disabled, we can't share that personal information on our website. So it's going to say residential, and in parentheses it will say multiple. That way you know that additional exemption has been applied. Also, under forms, we talked about the different forms that you can get. You click there. We also have additional information, helpful information, videos about various aspects of the property tax system, as well as other information. And this is at www.hcad.org, which is our website address. We're located at 13013 Northwest Freeway, and our phone number is 713-957-7800. You can also go online if you've got an opportunity to send us an email at this address shown here. I'll give you a minute if anyone's interested in taking a shot of that, but it's HTTPS. It's hcad.org/contact us US form. You can also currently go to just simply help@hcad.org. That particular address will be sort of going away because this one will allow us to service you a lot more efficiently because it gives you an opportunity to provide some additional information up front first, so we'll be able to send it straight to the correct person without delay. And that is my presentation for this afternoon. Thank you very much for listening, and I'll be happy to answer any questions that I can today. For any that I cannot answer, I'll be happy to take your information and make sure that you do get an answer.
Okay, thank you very much, Ms. Mabel. Ms. Jamie?
All right. Thank you so much, Mabel.
I don't see the discontinue share button. So Nia, can you do that?
It wasn't shared on your end. It was on mine. I was
Great.
transitioning. Okay. Yep. So you're good.
All right.
So do we see it?
Yes, ma'am.
All right, let me fly through this and have some time for Q&A. Just as Lisa and Mabel said, you know, you have to have the deed. You know, you have to have in order to get a lot of the benefits that comes from property ownership. And you know, part of our reasons for doing this workshops, you know, is basically to give you the information, the resources, and the wherewithal to go through this process. You know, on behalf of Ms. Ann Harris-Bennett, my name is Jamie Duong. I'm the Director of Property Tax here at the Harris County Tax Office. We welcome you to this workshop. And I know that you've been receiving a lot of information from our partners here. And one of the things I want to add to what Lisa and Mabel said is that it is very critical to have a game plan, you know, to have sort of a roadmap that says, okay, what do I need to do with this? What do I need to do with this? Because when that time comes, when you have to either be the executor or to be one of the heirs on this property, you want to have that information ready. And you want to know even the very minimum as far as who do I turn to get some information to take care of this business, because that's a very stressful time. And you know, we're here to help you. We'll provide all the information we can, and we'll help and guide you through the process. So reach out to us, okay? Again, on behalf of Ms. Ann Harris-Bennett, your Harris County Tax Assessor, Collector, thank you for making the time to join us today. We'll talk a little bit about property taxes, and then we'll open the floor up for questions and answer. And a little bit about the tax office, you know, we collect over $8 billion in taxes here, and of those, those can be your regular residential property to commercials to fleet to businesses. And some of those jurisdictions, up to 500 or so jurisdictions, we represent over 79 of those. And this includes your Harris County, City of Houston, your Houston Independent School Districts, and Department of Educations. Now, this taxes, as Mabel had said, it goes toward, to provide some of the services that are needed throughout Harris County. And your property tax bill have already been mailed, but how do we go through that process? That process starts with the appraisal and the property owner coming to an agreement on the value of the property. Okay, the value of the property, as indicated a little bit earlier, this is the time when you should have received already your property notice value in the mail. And I know the information is also available online as well too. And for the next step, within the next few months, the governing bodies of the taxing units will be on the tax rates. They'll have hearings and they'll have open discussions to talk about what is needed, some of the capital projects that are needed, and what tax rate. For this, they'll come up with a tax rate for the taxing units for the upcoming year. Once that's determined, the Harris County Tax Office will then basically take your value, have the rates, and we're going to apply any applicable exemptions. For example, the residential exemptions or the over 65 exemptions or any of the qualified exemptions that's been approved by the appraisal district, and use that to calculate your tax bill. And usually your tax bills are sent out probably about the late October or early November or so. On that, some of the recent changes to property tax law that affects your property tax bills. For example, Harris County recently increased the disabled over 65 disabled homeowners exemptions from $229,000 to $250,000. And recently, as early as last Tuesday's meeting, there was an increase in the exemption amount as well too. We'll wait for confirmation, but we'll certainly include that in our next presentations with a month of service partnerships here. And then also the City of Houston increased their over 65 disabled property owners exemption from $160,000 to $260,000. Of course, the school exemptions has also been increased from $25,000 to $100,000. And Mabel had mentioned that there is a eligibility for the prorated homestead exemptions to be calculated as of the date of purchase. Okay, and some of the latest bills that came out of the last legislative sessions, again, as I've mentioned, was the school homestead exemptions increasing from 40,000 to 60 to 100,000, limitations or cap on certain property value increases for property that are under $5 million, that's non-residential, and of course, requirement to restructure the school finance system or rate compressions for the school taxes. Okay, and when you get your tax bill, something to put notice on, if you're going to mail your tax bill in via regular mail, please be sure to, of course, include the payment coupon here. It helps us to properly post your payments. And also, if you're going to mail your taxes in as opposed to making other methods of payment, please, very important, do not wait till the last day to drop that payment in the mail. Very important. Why? Because according to the property tax code, if taxes become delinquent as of February the 1st. So if you're dropping it in on the 31st and the mailman has already picked up the mail for that location that day, it won't be picked up until the following day. So from January 31st to February 1st, and that's the delinquency, guess what? The average tax bill will now have a delinquency rate of 7% penalty and interest. So don't wait to the very last day to mail your payment in. There are other ways to make your payment. You can pay it online, or you can also pay it by phone. I'll go through the details on that with you a little bit later on. Prior in the presentation for the appraisal district, it was talked about the homestead exemptions, various types of exemptions. And this chart will show you the significance of applying and going through the required documentation, providing the required documentations to complete your process to get that homestead exemptions. For example, an average property of about 325,000 in Harris County. If you do not have an exemption on that, your average tax bill is going to be a little bit over 7,000. Okay. Now, if you have a general homestead exemption on that, you're saving about $1,800 on that tax bill. Okay. And then if the property owner is an over 65 disabled person, your tax bill now drops from $7,100 down to $2,300, a significant saving. Of course, this saving is only available if you follow through the process and provide the documentations to complete that exemption request. Okay. And as Mabel had mentioned in that presentation, you need to only apply once. Okay. But every year, the appraisal district will send you out notices and send out postcard to confirm that, hey, are you still living in this property? Please be sure to check that and review that, because it's very important. You know, and if you just bought a home or moved into a property and you haven't applied for that exemptions, you still have time. Please be sure to apply for that. Okay. Because if you don't apply for that exemptions, guess what? You're leaving money on the table. Okay, so some of the benefits for property owners that are over 65, disabled or disabled veterans, you get what is known as a tax freeze or a tax ceiling. Okay, and it's more of a limitations on the school taxes. And of course, there are other jurisdictions that would opt for this, but for right now, it is required for the school taxes, but not all jurisdictions have to provide this. It has to be voted on and decided upon by the governing body of the taxing units. Okay. And what this does is it says once the property owner turns 65 and applies for it and is granted this over 65 exemption, then the school taxes will freeze at that time, meaning the value may increase and other changes may increase, but the freeze remain as if they are at that time, you know, when they qualify for that over 65 exemptions. Now, does this mean their tax bill will remain the same every year? No. Why? Because there are other taxing units on that for that property that does not opt to have that tax limitations freeze. Okay. So when there is change in values or where there's change in the taxability of that property, that tax bill overall will change, but what will remain the same is the tax portion for the school district will remain unchanged, hence that tax freeze. Okay, and the other benefits to over 65 disabled or disabled property owners exemption is that you also qualify to request for a tax deferral. And what is a tax deferral? A tax deferral is basically where when the tax office sends you the tax bill, you don't have to pay the taxes on that. And yet you will not be penalized for not paying the taxes. And the interest rate on that is also different from the average unpaid tax bills. For example, on a tax deferred account, the tax payment is postponed. It's not canceled, it's postponed. Okay, the taxes are postponed and there'll be no collection notices. There'll be no foreclosure efforts on the property as long as that property owner that qualifies for that deferral remains at that property and is the primary residence for that owner. Okay, and the interest rate, as opposed to a normal delinquent account, the interest rate on a deferral account is only 5% per annum on any unpaid balances. And of course, you know, to have that deferral on the account doesn't mean you have to leave the taxes unpaid. No, It's just basically an insurance protection in case if you didn't pay that taxes. Okay, you wouldn't have to pay the higher fees on that. But when you have that deferral on the account, you can always make the payment on the taxes anytime. Okay, again, I want to emphasize a tax deferral is the delay in the payment of taxes. It is not a cancellation of taxes. Now, how do you go about requesting a tax deferral on the account? You go about completing an affidavit, and this affidavit form is available on the Harris County Appraisal, the Harris Central Appraisal District's website. Go on there at www.hcad.org. There's a form on there. You need to complete that and provide the required documentations. And I think it's also requesting a notary as well to that. So once you submit that to the appraisal district and they view and they qualifies you for that, then the tax office is notified of the deferral on that. So that takes effects for that year. Now, something to take note of is that if that property, it still has a mortgage company on that, we strongly suggest that you contact the mortgage company and let them know that you want to request a deferral, because there's certain mortgage company that does not allow for the deferral of taxes. Okay, so very important that you contact your mortgage company and consult with them first before you submit your application for tax deferral. Okay, so let's say, you go through the process of probate or you're still in the process of probate and now you find out that there are taxes that needs to be paid on that. What do? You need more time to pay. No worries. Reach out to us, contact us. We have payment plans that we can help you with. The payment plans are very flexible. They go anywhere from 12 months to 36 months. And, we offer this payment plan as a financial tool for the property owner or the heirs of the property owners, because having a payment plan on the account as opposed to nothing else is why. What are the benefits? Of course, it avoids the collection efforts. Okay, it avoids foreclosure efforts from the collection attorneys, and of course, it also helps to reduce the attorney's fees on the account, as opposed to a property that doesn't have a collection plan on that. So reach out to us. We'll be able to help you walk through that process to set up the payment plan. Now, if you're a property owner and you're over 65, disabled or disabled veterans, we have quarterly payment plans that we can extend to you. Okay, of course, this again is, it takes whatever's owed on that, divide that into 4 payments, and there's no penalty or no interest on that as long as the payments are made accordingly, at the end of January, the end of March, the end of May, and then end of June. Okay, so the primary requirement on that is that coding for the over 65 has to be on the account by the time you request for that payment plan, that quarterly payment plan. So it's very crucial that you go through the process, if you qualify for that exemption, to complete the documents and to complete the paperwork to get that exemption on your account. Of course, as I said before, for if you're not over 65, we also have payment plans available for you. We have the homestead plan, and then we have also the payment plan for properties that are rental properties or non-homesteaded properties. And of course, this goes as far as 36 months payment plan. Reach out to us. We'll walk you through the process. We'll help you set up that payment plan. Okay, so as I stated before, besides mailing in your payments, we have other ways that you can make your payments. Of course, the easiest way is to go online at www.hctax.net and submit your payments. You can also pay by phone at 713-274-2273, or you can, go to any one of our 16 branch locations. Get online to our website at www.hctax.net and see, where specifically would you be closest to which branch. Now, online payments and telephone payments, we accept credit card payments, which charges a 2.5% convenience fees. Of course, we can also take checks and e-checks. Those are free. There's no charge for using e-checks. And of course, if you're going to pay by cash, you have to go to a branch. Okay, you need to go to a branch to do cash. Do not mail in your cash payments. And if you say, hey, but that's all I have. Well, go to the post office or at one of the convenience store and buy a money order or cashier check and submit that in. Do not send your cash in the mail. And very crucial, as I've noted before, if you're going to mail in your payments, please go to the post office at least 2-3 days before the deadline and make sure you stand in line to see that postmark on the envelope, because payments timeliness is driven by that postmark. If that postmark is anything other than January 31st, guess what? That property may be assessed a penalty. So do not wait to the last minute to drop in your payment. Okay. And again, we are here to help. If you have any questions, reach out to us. Information is available online at www.hctax.net. You can also email to the tax office at tax.office@hctx.net, or you can call us at 713-274-8000. And that concludes our presentation, and the floor is open for questions. Please let us know.
Okie dokie. Let me see. I know there's a couple of the questions here in the chat. Let me go back up. Where is it? I know I saw it. Okay, there was a question here, Miss Lisa. This is for you. My spouse died now with no will 3 years ago. Both of us were on the loan and the title. I'm not planning on selling or refinancing anytime soon. Should I do an affidavit of heirship to only have my name on the title?
Yes, that's a very good idea to do. And I will put a link in the chat of a website. Our website has instructions on how to do an affidavit of heirship.
I think that's one of the templates too that I.
Oh, I think you may have.
Let me double check, but go ahead and put it in there, because if not, then I'll just grab it from there and I'll make sure that it's included as well.
And you can also do an affidavit of heirship for a motor vehicle.
Okay. If your name is, if you are named on the title of a property and are a surviving spouse, can you avoid probate?
You absolutely can. You can do an affidavit of heirship, like I just mentioned before. You can also do a small estate affidavit since you're a surviving spouse.
Okay. Ms. Jamie, this one's for you. Can you
Okay.
make payments on deferred taxes after your parents have passed and it was just discovered?
Oh, great question. Yes. And timeliness really, really matters on this. Aquina, Ernest? Yes, timeliness really, really matters. Okay. Here's the thing. When account is deferred, basically there's that 5% penalty, 5% interest assessed on that. Yet when your parents pass away and it's discovered, guess they're going to go back and they're going to say, okay, this is the date of death and it's going to be calculated. And that defer is on that account for 180 days. Okay. Once the 180-day pass, guess what? If there are unpaid taxes, it reverts any of those unpaid taxes back to as if it's normal delinquency period. Okay. So you discovered that, hey, it was just discovered, make the payment. Call us up, come to the office, whatever. Call us, let us know how much is due. And do your best to make as much payment as you can before that exemption is that date of death is removed from that account, because after the 180 day, on the 181st day, the delinquency is calculated as normal. Okay, so reach out to our office. We'll be able to help you with that. And also, I want to add something to this about the deferral as well too. If you're applying for that deferral, please make sure your heirs know. Okay, or make sure you add it to your will. Make sure you add it to the note to your file so that the heirs know that, hey, please reach out, because that tax is important,
And if they've got the deferral, can payments be done regardless if the deferral is there or not? So that way, at the end, there's not a huge tax bill that needs to be paid.
Correct, correct.
And then how far back are property deferred taxes? Like,
My
for how
goodness,
long?
we have cases where, you know, the parents deferred the taxes and then they give it to the child, and the child now just turned 65, 67. So the child takes it on another deferral. Super, super. We have some that are 15, 20 years.
Oh my
Yes.
goodness.
Yes. So it is a tax strategy. It is also a benefit if you know how to utilize it. But it can also be used. You should also use it with caution. Let the heirs know and make sure it's paid. You know, we have had situations where taxes are deferred, you know, since the 80s or so. And now you're in a property that is, you know, that used to be a $30,000-$40,000 house, yet now with that deferred coming off, and now the taxes are now amassed at normal market value, because you know, $30,000 house back in the 80s is pretty normal, and now you're coming up to something that is in a location that is just hot. Now remember, part of ownership is you get that cap on that property. And then you have an over 65 on that property. And then you add on the deferral. It's like ice cream with cherry, with whipped cream and caramel and sprinkles and, you know, all the wonderful nuts, and then a unicorn on top. And now when that's taken off and the property is in a hot prime location, it can be quite a bit of taxes to catch up on too, you know.
The contact information for the legal referrals, Ms. Lisa did put in the chat, but I will also include, it's the contact information for the Earl Carl Institute, Lone Star Legal Aid, Houston Bar Association that has the legal lines and the referral service, as well as Lone Star Legal Aid. Did I say Lone Star Legal Aid? Lone Star Legal Aid, Houston Volunteer Lawyers, the Earl Carl Institute, are the legal service organizations itself. And then the Houston Bar Association has the legal lines and the Houston Law Referral Service. So all of that information will be included in the email that I sent out. Okay. All right. So you've got an affidavit of heirship here. Okay. Yep. I think I do have that is included. Let's see. Which of the agencies Ms. Nelson provided will perform a legal consultation for a small fee?
None of them charge. They do have income restrictions. My agency, Texas Law Help, can give free legal information to anyone. And I say apply for everything, you know, don't count yourself out. And but if you do not qualify, Houston Lawyer Referrals will give you attorneys, and they have attorneys that give you a 20-minute consultation, a 30-minute consultation for $20.
And then you also have the legal lines. Houston Bar Association has the legal lines. So you can
Yes.
call in and talk to the attorneys over the phone.
Legal line is a great resource. It's available to anybody, and you get to talk on the phone with an attorney.
Okay. As an executor, can I submit an executor deed to transfer a property to a sibling, or must I use an attorney? What's an executor deed?
If you're an executor, you probably have an attorney, because you can't probate a will without an attorney. But you absolutely can submit an executor deed to transfer property.
What's an executor deed, Miss Lisa? Explain that.
It's like a special warranty deed, but it's called an executor deed because it's the executor transferring the property from the estate to whoever inherited it in the will.
Okay. So if they were, okay, Ms. Ernest, I'm not sure, you were referring back to a previous question about being over 65 and getting an exemption. Can you unmute and clarify what the question, the second part of that question is? I just want to make sure that it gets answered correctly. Okay, what is the income restrictions to get the free legal help? Ms. Ernest?
Hi, Miss Mia. I
How you
was
doing?
calling to find. I'm good. How are you? Thank you so much for this today. I appreciate all the help. I've received great information. Really have. A question is that if they were 65 and someone told them to sign up for deferral taxes and they should have been for an exemption, how does that work? Will they look off into for the exemption of 65, or do I have to continue to pay the deferral taxes when they were 65 when they did this?
Okay, so make sure I understand correctly. So this is for your parents, right?
Correct.
Okay, so when they're 65 and they sign up for the over 65 exemptions, that's one issue. Has nothing to do with that. Okay.
Right.
And so let's say they're 65 and they have some taxes, and this taken into account the deductions and everything. So they still have, a tax bill, right? Now,
Right.
the deferral allows them not to pay that tax. And
Okay.
yeah, and just, like postpone it for years and years and years and years and go. Now, this doesn't stop you. Let's say you're going to inherit this property. This doesn't stop you or anyone coming in and says, hey, I'd like to pay this taxes. My parents are still alive and they have a deferral, but I still like to pay this taxes. It doesn't stop you at all.
But what if they're deceased?
Okay, you can still also come in and pay that taxes.
Okay, for that year?
Yeah.
Okay, and then go back and find out how much of the deferral taxes will be. And
Correct.
Are they penalized and they have the fees on the deferral taxes also?
Yeah, well, it's not penalized. It's just the reduced interest. It's just that
Reduced
5% for the
interest.
entire year. Correct.
Oh, for the year. Okay, it's not
Correct.
every month. I got you
Exactly.
for
And
the
that's the
year.
big difference. You see, that's the big difference,
Right.
because if you don't have that deferral on that and the taxes are past due, let's say the first month that is past due, it's 7%. And then, 9%, and then 13, it goes on. And then by the time July comes about, there's an extra attorney's fees that's added to that. What I would suggest you do, Ms. Ernest, is contact us and then we'll let you know the amount, and then, make plans to pay that before that update comes in and says, hey, this should have been taken care of, whatever date.
Oh,
Okay.
okay, awesome. I'll be getting back with you. Thank you so much. Good information.
Yes, ma'am. My pleasure.
Thank you very much. Thank you, Miss Regina. Appreciate that. There was another question that was emailed to me too. That question is, how do I take over property that I have been paying taxes on and there are also other heirs?
That's a little more complicated when you have other heirs. Usually the first thing I would do, you have two options. You've got the affidavit of heirship, which would transfer the property to you and your heirs. You can try to ask your heirs to deed their property to you. Sometimes they're easygoing and they'll do that, but there are other times when they're not going to be so easygoing. But start by asking them nicely, hey, I've been paying the property taxes and I want to have clear title to this property, and see if they'll cooperate.
I want to add something to that, Lisa.
Please.
At the tax office, we've seen this happen so many times, and so often it's heartbreaking. Okay. If you're a parent and you want to leave the property to your children, think very, very hard as far as who would be paying the taxes, because that becomes the crucial issues. And like we say in our presentation, probate occurs usually in the span of 2, 3 or longer years. Okay. So that means you're going to have more than 1 year of taxes that has to be handled. And the easy thought is, I'm going to have my house and I'm going to divide that among my 3 children or my 2 children or my 5 children or my 6 people that I want to divide that out to. The thought is beautiful, but when it comes to property tax, there's one tax bill. Who's going to pay and who's going to go gather the money to make sure to pay that taxes? That's something to really think about.
And
And
I'll
for the
add
tax
another
office,
layer.
when the taxes aren't paid, delinquency kicks in, and that's where the pain is going to be.
And I'll add another layer to that, especially when you've got multiple heirs, and then one of the heirs is actually living in the house, has been living in it, maintaining it, updating, upgrading, and taking care of everything. And if it comes now time for the house to be sold, well, now, or the taxes to be paid, they expect that one to pay for it because you're the one living there. But if the house gets sold, well, wait a minute, we all deserve an equal share, even though I'm living here and I'm maintaining and nobody's paid for it. That causes a whole nother issue in itself. So there's all kinds of scenarios that actually pop up when it comes time to dividing assets, and it can create a snowball, and everything just kind of, so definitely sit at the dinner table, have these conversations well in advance so everybody's on the same page. There is no misunderstanding of who's going to be doing what. But unfortunately, in a lot of communities, people don't like having these conversations. Nobody likes talking about it. They think it's, it's a jinx or faux pas or whatever, just to even talk about it. But, and I say it in every session, if nothing else, COVID should have taught everybody something, that you don't know when something's going to happen. You don't know when somebody's going to pass. It doesn't matter your age, your race, your orientation, religion, whatever. You got something that happening to everybody on a regular basis every single day that you have absolutely no control over. And it's best to make sure that you have things kind of already in place to make sure things are can go as smoothly as possible. Of course, nobody can predict every single thing, but at least you've got some kind of things or some kind of measures that are in place already. Another question that was emailed to me was about credit card debt. It says, my wife passed away with unpaid balances on 2 credit cards in her name. I am also an authorized user on these cards, but the cards do not show up on my credit report. Am I still responsible for that debt?
You are only responsible for that debt if when your wife passed, she had enough money to pay those bills. Because you, if you're married, if you're a child, when you're the one who's in charge of an estate, you are personally responsible for that estate's bills. They get paid out of what the deceased person owned, what property they had.
So if it's a married couple and she had credit cards, but all of their bank accounts are community property, it's both of theirs, then how do you differentiate community property versus what was hers?
That's
and
a
now
great
part of
question.
the estate.
And it's more complicated than that. I mean, that's a good point. I honestly I'm not familiar. If he's not using the credit card, or whoever that is, if they're not using the credit card, and it's just funds from things that his wife bought, he doesn't need to worry about that debt. I mean, he can pay for it, but he doesn't have to.
Okay. And I hope he's listening, or at least go back and watch the presentation. And that answers the question. I think that was all the questions that I got emailed to me, and I don't see anything on Facebook. I'm trying to monitor Facebook and the questions that were emailed to me and the chat box all at the same time here. So I want to make sure, if I have not answered or asked anybody's questions, if you could please either unmute yourself or put a little thumb or a star or something, because I'm trying to go back as far as I can. Oh, I also want to make sure that I mentioned, because Rachel did have to step off, about the a month of service referral and pre-assessment program. She put the link for the form, or to go to the website to complete a pre-assessment. And basically it's like a one-stop shop where you complete a pre-assessment to determine if you could qualify for any of the legal service organizations, and then they will contact you based on your eligibility, or kind of like the pre-assessment or whatever. And that way you're not applying here, applying there, applying here, whatever, or to kind of, or even, if you want to apply for all 3, then make sure that that you kind of specify that on the form, so they can kind of start that process for you. But you still know that you do still have to complete, even though you're doing a pre-assessment, this is basically kind of see if you income qualified. But you still have to actually complete an intake process, or go through the intake process once you apply for these services. So, and do not automatically discount yourself and automatically assume, oh, I make too much, or I have too much in assets, or whatever, I'm not going to qualify. Because people think, you have to income qualify, that it has to be basically next to nothing in order for you to be able to do that. And in a lot of cases, it's not the case. But there are services that are out there that are available to you that you can't take advantage of, that are for free. because going through the probate process is costly. It
Yeah.
can be very expensive. It can be very complicated. And I know there's a lot of do-it-yourselfers and YouTubes, and we provide these documents and things like that, but it's still a lot of intricate little details sometimes that you don't necessarily know about when it comes to creating an estate plan. And later on in the fall, we are also going to be doing a presentation about estate planning as it relates to qualifying for Medicare benefits, or state benefits. So you don't want to be able to disqualify yourself when you're building all these assets and keeping them all in one nice little bundle, but then the state tells you you can't qualify for certain services because you've got all of these assets here. So we're going to get to talking about that.
That's
And
fabulous.
Lone Star is going to be doing a presentation with us about that. So you guys make sure you tune in for that, because that is definitely going to be a very good one for you guys to know about. So are there any other questions here or anything else, Miss Mabel, that you'd like to add? If you want to give a last announcement really quick about protest deadline.
Oh, yeah, I guess there is that. Just for folks who are planning, who may be considering protesting their property values, as those have kind of been hitting the mail here recently, you do have May 15th is the usual protest deadline. However, look carefully at your value notice, because so many of them went out later this year that you always have 30 days from the date of that value notice. And for the majority of the value notices that went out this year, that's going to be May 20th. I hesitate to say May 20th because we want to keep May 15th in mind forever and ever as the official deadline. But because they went out late this year and they went out about 5 days later, the protest deadline is going to be on May the 20th. However, just check your value notices to make sure that you meet that 30-day deadline, whichever date is later. And I think that's pretty much the main thing we wanted everyone to know about that, because you have the opportunity. And also remember that if you're interested in, if you're just the slightest bit curious or not about how your properties were valued, please remember that the information that in order to get HCAD's information about how your property was valued, you will need to file a protest because of confidentiality laws. And I say this because you can file the protest, and that allows us to legally share that information with you. And you may look at it and go, it's going to show the other values in your area and et cetera. And you may say, oh, well, I guess you were right, HCAD. I will, you don't have to go through with the protest. And filing a protest costs you nothing.
I will also include the presentation from yesterday, because there were a lot of questions that were answered about the protest process, and a lot of resources and information that was provided by the exemption specialists and the protest specialists that were on. So I will include that link from yesterday's meeting so that you guys can go back and watch that. In addition, I will also be including the link from last week's, or kind of part one of the wills and estate planning session, so that you guys can go back and watch that as well. And again, we talk about all the different documents that actually make up an estate plan, and alternatives to writing and creating wills, how they're executed, what needs to be notarized, what needs to be filed. All of that information is included on that presentation, along with those templates, the affidavit of heirship that Ms. Lisa referred to, as well as there was something else that you put in the chat. That disaster
Oh,
booklet.
it's the Lone Star Legal Aid disaster handout.
Yeah, I will put that in, because
It's very helpful.
And hurricane season is getting ready to start next month, so that'll definitely be helpful. So you guys keep that in mind as well, because we are supposed to be having a disaster preparedness workshop for, I believe, the first or second Tuesday in June. So as you guys can see, how kind of one workshop kind of rolls into another, that rolls into another, that rolls into another. All of these things are kind of related in some form or fashion or another. And this is kind of how we kind of keep expanding the offerings and the resources of that month of service wants to provide, because we started talking about the wills and estate planning, and then we started talking about, well, what happens after someone passes, and we did the what happens after my loved one passes, and then we got into all those questions about the inherited property and clearing the title. Then we created that workshop, and then we wanted to make sure that HCAD was included in this presentation. And so it keeps going and going and going, because there's so many intricate little layers when it comes to building and protecting your assets and maintaining that generational wealth that people just don't know about. They don't think about, or they've heard again from the street committee about, you know, this is how I did it or how it was done and so on and so forth, and got it all wrong. So by the time it kind of gets back to where it's supposed to go, now everybody's kind of putting misinformation out there. So we want to make sure that you guys, yes, ma'am.
I was just gonna say real quickly, if you don't mind, we've just about completed our series of protest workshops that we do this time of year for individuals who want to familiarize themselves with that process and they'd like to take advantage of that, right? I did want to mention we have one more left.
One more.
Which is on Tuesday,
14th.
May the 14th. And that is going to be actually an in-person one here at the HCAD offices at 13013 Northwest Freeway, starting at 10 a.m. So if you're still interested, and that gives you an opportunity, you can file your protest in person when you come, because be with the deadline, the at least statutory deadline the following day. So that is May 14th, 10 a.m. here at the HCAD offices.
And I have that flyer, and I will include that as well. So you guys will have that information too. So with that being said, thank y'all for coming out and for tuning in. Feel free to come back next month if you think there's another question or think of something that somebody didn't ask, or if you want to invite somebody, your neighbors, your seniors, or somebody that want to sit and hear this presentation. This is a lot of good information for them to sit down and kind of sit around the computer and listen and to get the information about. So refer it to your family members, friends, co-workers, or whomever that you know of that could utilize this information. It does us absolutely no good to keep this information to ourselves. We have to pay it forward to as many people as we possibly can. So thank you guys for tuning in. What do we have? Today's Thursday. Tuesday, we have the Texas least commonly known traffic laws that people have no idea that are on the books. I was looking up some of these, and it's like, really? You guys are going to be really surprised when you see what kind of traffic laws that Texas has on the books coming up on Tuesday. So we have that one next week. We also have on Wednesday, maintaining and adding value to your home. And then we've got evictions, reverse mortgages coming up, coffee and conversation is coming up. And in neighborhood recovery, we have a part of our senior security series. We're talking about our retirement planning. What happens when you leave one job and you go to another and you've got a 401k or some kind of retirement that you had from years ago? What happens to it? Don't nobody know. Everybody just kind of forgets about it. But we're going to be talking about that as part of our retirement series. So join us next Thursday for that. So we will include the links to everything that was mentioned here today. Is going to be included in the email that gets sent out to you guys. If you do not receive it, then please feel free to reach out to me at nmurray, NIA, or N as in Nia, Murray, MURRY at nrcdc.org, or reach out and give us a call, 713-520-5232. But my contact information will be included in the email as well. So if y'all have any other questions, feel free to reach out. If there are questions for Ms. Lisa, Ms. Jamie, Ms. Mabel, their contact information will be included for the tax office and the HCAD for you to call for more information there as well. So thank y'all again. I know we're a little over on our time, but we're gonna yield it back to you guys. Thank you, Jamie. Thank you, Miss Lisa. Thank you, Miss Mabel, for providing this information and being a part of a month of service. Without the participation of you guys and the volunteers, you all have access to a lot of good information and a lot of good resources that you can take advantage of. So, and we thank you and we appreciate all of you very, very much. So y'all have a wonderful day and a wonderful afternoon. Take care of yourselves and stay safe. And we will see y'all again next time.
See you next time. Thanks for coming.
All right.
Everyone. Bye
Bye-bye,
now.
Ms. Carr. We'll see you up there. Thank you, Miss Ernest, Miss Regina, Miss Tanya. Appreciate you guys.